Hello everyone. In this presentation, the focus would be on understanding the basic principles of criminal liability. We have seen that there are three essential attributes of crime. Crimes are acts or omissions commanded or forbidden by law. They are prevented by infliction of punishment by the state. This is done only after following a procedure prescribed by law. The next question would be, when will an individual be liable for the commission of a crime, or when will he be held criminally liable for his act or omission? There are three basic principles of criminal liability. The first principle is that an act will not amount to an offence unless it is prohibited by law, expressed in the Latin maxim, nullum crimen sine lege. The second principle is that no one can be held liable for an omission unless there is a duty imposed by law to do the act and there is a willful omission of such duty, again expressed in a Latin maxim, nullum peona sine lege. Example, not providing food to beggar which results in the death of a beggar will not make a person liable for his omission, but where he omits providing food to his wife, children and parents, he would be liable because there is a duty imposed upon him by law to feed them. The third principle is that an act does not amount to a guilty act unless it is done with a guilty mind. The Latin maxim is actus non facit rem nisi mensit rea. From this follows another maxim, actus me invito factus non est mens actus, which means that an act done by me against my will is not my act and hence I cannot be made liable for the act. Therefore, in order to make a person liable for a criminal act, it must be shown that the act which is forbidden by law is caused by the conduct of the accused or is committed by the accused, and that the accused did the act with a blameworthy or a guilty mind. For example, where A throws a stone at a tree in his garden to pluck a fruit, but the stone hits B, who is hiding behind the tree, and caused hurt. A would not be liable for causing hurt because he was trying to pluck a fruit in his garden and did not know about the presence of B and did not intend to hurt B. Thus, there are two components of every crime. They are actus reus, that is the guilty act which is the physical element, and mens rea, that is the guilty mind, which is the mental element. Actus reus is the guilty act or the result of human conduct which the law intends to prohibit. This actus reus again consists of three components: the human action, which is termed as conduct, the result of such act in specified circumstances, which is termed as injury, and such act is an act which is prohibited by law. The human action, that is the conduct of the human being, can further be split into three aspects: the willed movement or omission, which takes place under certain circumstances and which produces certain consequences. These consequences result in injury, and the act which produced this injury is the one that is prohibited by law. All this constitutes the physical element or the actus reus of the crime. Let us take an example to explain the various aspects of actus reus. Supposing A shoots at B with a rifle. Here, A, by a series of voluntary muscular movements which are willed, lifts his hand, raises the rifle, pulls the trigger, releasing the bullet. Here, the circumstances are the rifle has to be loaded and in working condition, and B has to be within the firing range. The consequences are the fall of the trigger, explosion of powder, discharge of bullet, striking at B and causing injury or death of B. Here, the result of the human conduct, that is the conduct of A, is injury to B, which if caused without any justification is prohibited by law. Thus, the actus reus of a crime of A causing injury to B, stated as A shoots B with a rifle causing injury, involves all these aspects: willed or voluntary movement or omission under certain circumstances, resulting in certain consequences, causing injury to another person, which is prohibited by law. But mere physical element is not sufficient to make a person liable for a criminal act. The physical element has to be accompanied by a mental element. In the above example, if A was a shooter practicing shooting in his property, after exercising care and caution, and B enters A's property without notice and gets injured, A will not be liable because there is no guilty mind which wanted to cause injury to B. But where A with an intention to cause injury to B shoots at B, he will be guilty of the criminal act. The mens rea or the mental element for a criminal act may take any of the following forms. It may be in the form of intention. What is intention? Intention is doing an act voluntarily with a desire to bring about the consequences which are natural and reasonably foreseeable as following the act. When A fires at B from a close range voluntarily and B dies, A is liable for causing the death of B because the act was voluntary and the consequences were the natural and foreseeable consequences by a prudent man. Here, it is said that A had intentionally caused the death of B. Motive. Motive is another form of mens rea, which is the reason for which a man intends doing an act and does an act. For example, A and B were already involved in a property dispute, had frequent quarrels, and threatened each other of dire consequences. Here, when A fires and causes B's death, there was a motive for his doing so. But so far as deciding criminal liability is concerned, motive is irrelevant. However, it helps us to find out whether the act was intentional and can be taken into consideration while assessing the quantum of punishment that has to be imposed in a given case. Knowledge. Knowledge is another form of mens rea. Here, the accused knows what the consequences of his act would be and does the act, but does not desire to bring about a specific consequence. For example, A fires at a mob and causes the death of B, who was in the mob. Here we cannot say that A intended to cause the death of B because it was not his desire. But he would still be liable for the consequences because, being a man of ordinary prudence, he is deemed to have known that firing at a mob is likely to hit someone in the mob and cause his death. Yet another form of mens rea is recklessness. It is a state of mind of a person who knows the consequences of his act, does not desire for bringing them about, but at the same time he is quite indifferent to the consequences or does not care about what happens. It is an attitude of mental indifference to the obvious risk. For example, driving at a furious speed through a narrow and crowded street is a reckless act. Negligence. Negligence is another state of mind where a man does an act without taking into consideration all its consequences. It denotes want of care and caution which a reasonable man would have taken in the given circumstances. For example, where A, who was having a quarrel with his friend, threw a paperweight at him which missed him and hit B, who was sitting in a corner of the room. A would be liable for causing injury because, though he never intended to cause injury to the person sitting in the corner, yet he failed to conform to the conduct of a reasonable man. Thus, in order to make a person liable for a criminal act, in addition to proving that the physical act was caused by him, it must also be proved that the act was committed with a guilty mind, that is, mens rea, which may be in the form of intention, knowledge, recklessness, or negligence. Now, is this doctrine of mens rea applicable to the offences under the Indian Penal Code? The framers of the code have not mentioned mens rea as such anywhere in the code, but the doctrine has been incorporated in two ways. First, the provisions regarding mens rea that is required for a particular offence have been included in the section itself by using such words as intentionally, knowingly, voluntarily, fraudulently, dishonestly, etc., depending on the gravity of the offense concerned. For example, causing death by doing an act with an intention to cause death, with an intention to cause bodily injury which is likely to cause death, or with the knowledge that the act is likely to cause death, amounts to culpable homicide according to section 299 Indian Penal Code. With a dishonest intention to take movable property out of the possession of another person without his consent and moving the property in order to such taking amounts to theft under section 378. Thus, mens rea is included in the definition of the offense itself. For culpable homicide, it is intention or knowledge, while in theft, it is dishonest intention, that is, intention to cause wrongful loss or gain to another person. Second, the concept of mens rea is incorporated into the provisions pertaining to general exceptions contained in chapter 4 of the code. For example, mistake, infancy, insanity, intoxication, accident, etc. are situations where there is lack of mens rea, and necessity, consent, right of private defense, etc. are situations where the circumstances justify the commission of the act, which would otherwise be an offense. So all these are put under chapter 4 of the Indian Penal Code in the form of general exceptions. Where the legislature omitted laying down a particular state of mind as an essential ingredient of an offense under the code, the presumption is that the omission is deliberate, and in such cases, the doctrine of mens rea will not apply. For example, in offenses like waging war against Government of India, kidnapping, etc., no element of mens rea is required for the commission of the offense because Section 121 says that whoever wages war with Government of India shall be punished with death or imprisonment for life, and Section 361 says that whoever takes or entices away a minor out of the keeping of the guardian without the guardian's consent commits kidnapping. No words denoting mens rea like intention, knowledge, negligence, recklessness, etc. are included in the definition, and hence the presumption is that the omission is deliberate. Thank you.